Hello and welcome back to Hill and Ponton's YouTube live channel. I am attorney Allison Reddick and I am back with attorney Rachel Cheek. How are you doing, Rachel?
Pretty good. How are you, Allison?
Good. So we are here to answer some questions for you for the next hour and we'll go ahead and jump right into it. You want to start or do you want me to start?
Let's see. I'll go ahead and start. So another step asks, I filed claims for hives and OSA, sleep apnea, and included DBQs for my civilian medical providers. I did not have a CMP exam for either, just VA contracted IMOs, and both claims were denied. And I'm going to guess here that IMOs is referring to medical opinions, CMP medical opinions, most likely. Filed supplemental claims for both and included my own private independent medical opinion with each. VA has notified me that, again, I will not be having CMP exams and is using the same contractors for second IMOs. Okay. Is it common to not get a CMP exam for both the initial claim and supplemental? How does the VA decide to use CMPs versus medical opinions? How am I supposed to be heard? That's a good question. You want to start that off, Allison?
I mean, the terminology CMP and independent medical opinion, that's not how I would use this. At the end of the day, they're disability benefit questionnaires that are all CMP exams. If they're from the VA, they're CMP exam, regardless of if it's a VA provider or if it's someone they contract out. I have no clue how they decide. I would assume it is where you live, how many providers they have in the area. To me, it seems like the majority of them, they're contracting out. I very rarely see from actual VA providers as much as I see ones that are contracted out, which in my opinion, the contracted out ones, I've had horror stories about people going to a strip mall and there's no one there, or the last one they were eating candy and asking them questions and it was an ortho and they didn't even touch them. So we don't really know how they decide which one to use. And normally, yes, you will get an initial CMP examination, which that's interchangeable. Both of them are CMP examinations. If you have something in service or a primary service connected condition to warrant a CMP examination. But a lot of the times for the supplemental, they're most likely not going to give you another one. Usually they'll just review the record and deny it.
What it seems like, though, Allison, is for this particular case, I agree with you on the horror stories of contractors. I think he's asking, he has not been examined at all. They're only doing a medical opinion. I think that's what this particular question is. And that is not normal. I think if you've got a diagnosis and you submitted it with medical evidence, they should give you a CMP exam, at least at one of those points. I would file a higher level review appeal and say that was a duty to assist error. VA did not assist you in scheduling an actual examination. No one looked at you. They just took a glance at your records. So in that case, I would higher level review that.
See, but it says I did not have CMP exam for either, just VA contracted IMOs. So maybe they had record reviews. Or it could be a records review. Regardless, you should be able to speak with someone during it. So I agree with Rachel. I would do a higher level review and say there was just a medical opinion or it was just a records review, which you have to do a records review to get a medical opinion. And I want an examination where my lay testimony can be heard because that's a part of it. Also in the higher level review, I would point out the DBQs that you have from your civilian medical providers, because whether it's direct service connection or secondary service connection, they should be reviewing those as well and accepting them.
Yes. And he just commented he was contracted out for CMP, but he didn't see anyone. They only did records reviews and medical
records review. Yeah, I've been seeing that a lot. And so if I see a denial, especially if it's initial or supplemental, that's the first thing I'll look for. I'll look and see if it was a records review. If it was a records review, how are you getting any information from the vet? I just had one where it's a vet with cancer and they did a records review and reduced his 100% rating to 30%, and he still has cancer. And I'm like, how are you going to reduce this without even talking to him? So that is a huge thing. Your voice does matter, and you should be able to speak with someone, whether it's a video conference or an in-person exam.
Absolutely.
Okay, next question. John Johnson, BVA decision remanded twice for inadequate exam from ACE exam, sleep apnea secondary to tinnitus. What should I do? Get a nexus opinion. They will keep this is the way I think of it. They're remanding it, then that means there's enough there that they're not denying it. So I've seen 3, 4 remands, and it's really annoying. But if you keep coming back and giving the evidence that you need, eventually it will most likely get granted. Sleep apnea secondary to tinnitus is hard. But if you get a medical opinion with medical literature showing how the tinnitus affects your sleeping, how you're waking up, how it caused the sleep apnea, then you should be able to get it connected. But yeah, I would just go back up with independent medical opinion. Rachel?
No, that's a great point. Like Allison's saying, they'll remand it back and back, and think about for the VA, at least as likely as not, 51%, 50%. The more weight you put on the scales in favor of you, like medical evidence, all that, like you're weighing the scales more in your favor. The weight of the evidence is literally what they consider. So think of it that way.
And 2 remands, it's been pending for a while. So that's probably a significant amount of retroactive. They want you to give up. They want you to not appeal it. But if you keep that appeal stream going and keep fighting and giving more evidence, usually they'll give up, especially if you have good medical opinions.
Mm-hmm. Let's see. All right. Gateway asks, is it a duty to assist error if the VA knew I was applying for Social Security benefits, but didn't inform me of the possibility of applying for individual unemployability for the same condition? That's a good question. So they are supposed to notify you if your service-connected conditions are, like if you meet the scheduler criteria, meaning you have at least 70% combined rating or a single condition rated at 60%, and there's evidence in your file that you are not working, and there's any indication that that could be due to your service-connected conditions, then yes, the RO is required to notify you and send you a VA Form 8940 and let you know about individual unemployability. What would you think, Allison?
My question is, did you submit your Social Security application and those records to VA? Because then they're on notice. Even though they're both government entities, VA is not going to go out and look for these things for you. If you put them on notice and you sent those records in, then yeah, absolutely, it is a duty to assist error. But regardless, if you have a qualifying rating, I still think you have that argument that they should have provided you notice with an 8940, which they never do. And if you're still within the appeal period, absolutely appeal it, whether it's a higher level review saying, I have a qualifying rating and I'm applying for Social Security, or supplemental, and file those Social Security application as evidence that you're unable to work. Tiny. I am diagnosed with moderate sleep apnea and also PTSD. The VA prescribed a CPAP machine, which I couldn't tolerate, so I was supplied with an oral device instead. Will I qualify for 50% sleep apnea, the same as the CPAP? So I know, at my BVA hearing, the judge asked me if I felt that I received an adequate C&P for my back injury, lumbar strain. I said no. Should I anticipate the judge ordering another C&P exam? I guess I'll answer the second one first. Depends on the judge. I don't know. Just because he asked you that, he could say, yeah, I'm going to remand it for a new exam, or he could just say, regardless of whether it was a good exam or not, I don't think that there is service connection, or I don't think that there is entitlement to an increased rating. We can't read the judge's minds. They do what they want. The fact that he asked, that's good. And that you said no. So there's a potential, but I wouldn't really think about it too much until you get a decision. And then back to the first part, they prescribed a CPAP machine, which I couldn't tolerate. So I know that there are pending comments, or there's pending on changing respiratory, right? And that if you aren't using your sleep apnea or your CPAP, they're not going to give you that 50% rating.
I'm not going to worry about it until I'm not going to worry
Okay.
about any pending things until they're changed. Until those pass, then what's now is good law. So to what now and is in the requirements is a continuous, I believe it's
Positive pressure
positive
apparatus.
pressure device, such as a CPAP. So I would think that the oral device, it's serving the same purpose as a CPAP. It's making sure that you can breathe while you're sleeping. It's providing air. Yes, you should.
And based on the current criteria, if in your VA records it says you're prescribed a CPAP, that's enough for me.
Mm-hmm. Even if it,
yeah, I have vets tell me all the time, yeah, I'm prescribed it, but I don't use it. And I'm like, okay, well, you didn't tell me that. It's in your records. I don't care. Just kidding.
Next question, please. Lonnie Brenson. My current rating, SMCM, loss of use of both feet and 100% bowel incontinence. I have other separate severe disabilities at 60%, 60%, 50% to 30%, which I filed for aid in attendance. It was denied. My decision letter. Do you have a next part to that? Fellas? All right. Well, I don't know what the next part of the question, but I will say just reading this off the bat without actually looking at your rating sheet and knowing what those separate disabilities are for. If you're granted aid in attendance and you have an SMC rating and 100%, what?
To me, why they would deny it is if there's non-service connected conditions that are contributing to your need for aid and attendance. We don't know what your ratings are and you have 100%, but aid and attendance, sometimes they'll deny it because of those non-service connected conditions. That's the only thing that I could think of. Or the aid and attendance exam didn't show that you needed help with X number of activities of daily living. With that, I would make sure that you file a 2680 aid and attendance form if you can from one of your providers, only putting your service connected conditions on there and how they affect your ability to conduct your activities of daily living on your own. That would be the only thoughts that I would have with the limited information.
I would also know if you have loss of use of both feet, that puts you at SMCL. And if you can get aid in attendance for conditions, maybe those conditions such as bowel incontinence and the other disabilities that you note below, if you can get aid in attendance for that, that does not consider your loss of use of feet, so just take that out of the equation, you could be eligible to a much higher level of SMC based on the way that VA combines those ratings. So whenever you do go back to VA and you get a form, you have your doctor fill out a form for aid in attendance, ask them to consider the conditions that aren't your loss of use of feet, and if you would still need aid in attendance due to that, just to maximize. Next question.
Okay, Timothy, been rated for PTSD at 100% for over 5 years. Thinking about applying for aid in attendance based on medical notes from my clinical psychologist stating sleep deprivation complicates memory and focus, and on some days it takes a toll on my ability to care for myself. He has left the stove on in the past, so he protects himself from this hazard by using the stove only when spouse is home. Also, my migraines rates 50% caused me to be bedbound, and my physician put a note stating that I require from my spouse for dressing and toileting. Should I apply? Okay, so your rating has only been in effect at 100% for 5 years. Anytime you put in any new claim, it's going to reopen the possibility of your rating being reduced. So the fact that you're at 100% for mental health, that's really hard to get. I would be wary opening a new claim. Also, with aid and attendance and opening a new claim for 100%, I don't know whether you have competency or not, but that's also a red flag that would raise that anytime you have 100% or high ratings for mental health, they're going to worry about your competency and whether you can manage your own finances. So that's something also that you could potentially be risking. Aid in attendance, yeah, you can get it for protection from hazards, but you would need a significant amount of evidence. For me, that's a big risk that I wouldn't be willing to take. What do you think, Rachel?
Well, I work with Carol, so I'm going to say go for it. Can we go back to the first part of that question, please?
Yeah, but he's only had 100% rating for 5 years. That makes me
Okay,
nervous.
agreed. That does make me nervous. So here's what I would still say go for it, but here's some things that you should be cautioned of if you're going for aid attendance and you have 100% for mental health. Allison is absolutely right. Something that they will look at is competency. And when VA talks about competency, that means only they're considered with your ability to manage your finances or direct someone else to do so. So, for example, I've seen a lot of vets sit down for these exams. It goes well. They say they need aid in attendance, and they ask, well, who pays the bills in the house, or do you pay the bills? And the vet might say, no, my wife handles all that. Not because that was a direct question asked. Then it comes back where that CMP exam, the examiner states he can't handle his own finances. But that's not true at all. Just because someone else is dealing with the day-to-day, like literally touching and paying the bills, doesn't mean you're incompetent. As long as you know what's going on, the amount of money coming in per month, big debts, big purchases you talk about as a couple. There are ways to, it's really hard to find someone incompetent, although it is a risk. So if you are confident that yeah, I know what's going on, I'm not really at risk. Even if they try to show that I'm incompetent, we have ways to show that, which is like a statement saying all of those I just mentioned, you make decisions together. A statement from your treating doctor just saying, this has been my patient for however long, and I find him perfectly capable to manage your own finances. Just because you have 100% PTSD doesn't mean that that is necessarily a symptom of it. You could be rated for completely different things. So I would say give it a shot. Do be cautioned. I guess weigh what you think, because that is a chance. What Allison points out, you're raising the idea of more compensation, which means they're going to look at your rating. But if your symptoms haven't improved, you're at the same level, and you can, confidently say, yeah, maybe you don't handle the bills, but I know what's going on. It's not like you're going to go out and buy a new car without talking to your spouse. I would go for it.
Normally, to get 100% rating for mental health, you have to have delusions, hallucinations, danger to yourself or others. And I'll see people get it who don't have those things. And I'm like, be happy you got this rating. Leave it alone. Unless your mental health and with the competency thing, when they propose your competency, it takes a while. Like that's a process. Like that's something I don't want to risk. I mean, if it happens, of course you can try to get it back, but that's a month-long process that can take 6 months, if not more sometimes.
And this process she's referring to is if they find you incompetent, that means they don't give you your payments anymore. And they'll appoint a fiduciary, which usually is going to be someone you're related to, like a spouse. But if you don't have someone like that, they'll assign someone from VA. So
and the fact that he says some days it creates a toll. Some days is that regular care. No, for me, it's yes for Rachel.
I would also say one more thing with the memory. If you need medication management, as in you don't remember what pills you take, or your spouse sorts them and they remind you when to take them, that's also a consideration for aid attendance, because if you don't take them at the right time, that's a hazard. That's a hazard in your daily environment. So yeah, split down the middle. Happiness asked, any updates on caregiver supplementals this week? Not on our end. The caregiver program is moving incredibly slow.
I think the first appeal I filed was in 2021 or 2022, and I've had 2 decisions. One was good and one was a denial. Right now, the caregiver requirements are so stringent. You have to need assistance every single time you do an ADL. If you don't need help every single time, they're not going to give it to you. And the mental facet of it, of whether you have complications of some neurological condition where you need protection, there's the terminology is so vague. And I know there's a comment period right now where they're trying to get those amended to be reduced. So I would not count on caregiver right now just because of how intense it is. Though I have seen some grants. It's taking a really long time, but in the appeals process, I've gotten one grant and one denial. So yeah, I hope they reduce the requirements and fix up the language so it's better to understand. Like right now for level 2, it's an inability to sustain, self-sustain in society. Like, what does that even mean? And there's no definition for it. So no updates on it. It's taking a really long time. And if we find out more about whether those requirements are going to be changed, we'll let you know. Okay, if hubby, happiness again. If hubby is getting a Cephally device for migraines and a 12s device for back, should we add it to undecided supplemental, or will that add so much more time? It's already been 6 months. If your supplemental is pending, you can continue to submit evidence. I would definitely submit information stating that you're going to get the Cephally device for the migraines, because that's showing that your migraines are so severe and that pharmaceuticals are not helping, or you're having such a high frequency of them, as well as the 12s device for the back. Again, you're having so much pain that other remedies are not helping. So yeah, I would, if you haven't gotten a decision and it's supplemental, continue to submit evidence if you have it.
Totally agree. And now does that mean VA will consider it? Not necessarily, but if you submit it before a supplemental decision, once you get that decision, if it's a denial, make sure it lists that evidence that you submitted about these new devices. It should be listed on the rating decision, whether it's a grant or a denial. If it's a denial, they already have that evidence. You take that right to a higher level review appeal, and you don't have to wait the additional months and months and months to submit new evidence with another supplemental appeal. So yeah, get that in as soon as you can. And it won't add more time. That was her question. All right. Dan Armstrong. I'm a Blue Water Navy Vietnam veteran qualified for Agent Orange exposure. I have not filed a claim to date. I have ischemic heart disease. Okay. And prostate cancer, intermittent hormone therapy. The cancer metastasized during a break from hormone therapy, and I was placed on permanent hormone therapy. Will these disabilities be rated at 100% each? If so, will I also qualify for SMCS? Okay, Dan, you got to get that claim filed. You know that, so you're asking the question. When you have active cancer, yes, it is rated at 100%. I would say the fact that you're on permanent hormone therapy for the prostate cancer means that they would, unless that permanent therapy stops, which doesn't sound like it will, your 100% rating will continue for that. Can we go back to the first question?
It's a heart attack with a defibrillator. It would be a temporary 100% for the defibrillator, but then your rating would be based off of the symptoms that you have associated with it, whether it's chest pain, breathlessness, fatigue, episodes of fainting, dizziness, things like that, or other evidence seen in your CTs and such, like cardiac hypertrophy, things like that.
I know we have a video. I remember all about like how heart conditions are rated. I think Nate will put that in the chat if you want to look more at that. But I like what you're asking. You don't even have a claim filed and you already know about SMCS. So when you apply, the prostate cancer would be rated at 100%. You would have presumptive service connection. The heart disease, depending how bad it is, if it's rated at least 60%, you would be eligible for SMCS with that in combination with your the 100% prostate cancer. But please file your claim like today.
Or if you're not ready to file your claim, file an intent to file. That gives you a year and protects your effective date starting today. So if you file 6 months from now, you'll get that effective date back to your intent to file.
Very good advice.
Okay, find your focus. What qualifies as separate and distinct when going for half and full steps increases beyond SMCL, i.e., are secondaries to the condition that qualified for the half step eligible for additional steps? Rachel?
Let me take this one. Okay.
Yes.
The SMC is getting to be my new favorite topic. Just call me Carrie Baker. So I had to scoot up to let you know. So it depends. Separate and distinct, I have been taking as different. The symptoms are different from whatever causes you to need the SMCL. So let's use an example. The SMCL you have for aid and attendance based on a back condition that you have is very severe. They gave you aid and attendance just for your back condition. You have, 50% ratings for radiculopathy. That came down the line. You wouldn't be able to use the radiculopathy because it's directly secondary to your back. The radiculopathy would not serve as a separate and distinct condition that would give you that additional ratings that you could use to make these jumps. It would need to be something completely unrelated, like a mental health disorder. Even if it was secondary to your back, I would argue that, like, if you have a mental health disorder rated at least 50%, the symptoms from that are going to be different than the ones you have the pain and limitation from your back. Obviously, like, just completely different diagnoses. I would say, I wonder, Allison, what do you think? Would you be able, if a veteran has a back condition, service connected, they're getting aid attendance for it, and then they have two shoulder disabilities, and that combines to 50%. It's not related to the back injury, but it is orthopedic. Would you argue that was separate and distinct?
I would argue that's separate and distinct because it's
Okay.
different abilities
Yes.
and uses of the body.
Yes, I agree. Somewhere I don't know that you could use it. Well, never mind. I'm not even going to give an example where you can't. I would need to see the specific ratings. But basically, the symptoms need to be different enough, and they should not be directly secondary to cause the same symptoms. I think you could use, if you had aid in attendance, SMCL for a mental health condition, and you had, for example, a 50% sleep apnea rating, even though that was secondary to your PTSD, I would still argue that was separate and distinct because it's different symptoms. The back one doesn't work because it's the same limitation of motion, and it's pain that's literally radiating from the back. It's all continuous. So see what symptoms you can separate is what I would say. All right, my throat hurts, Allison. You take this one.
Okay. Another step. Oh, it's too much talking. Another step. Good afternoon. VHA Directive 11342 states that your VA provider must assist you with DBQs IMOs. My VA providers claim to know nothing of this policy or say they are discouraged from completing DBQs. Without their assistance, I have had to spend money and time to get DBQ IMO from private sector. How do we fix this? Thanks for what you do. Appreciate your time. VHA, Veterans Health Administration, which what the providers are, and Veterans Benefit Administration are two separate entities. I hear this all the time. Very rarely will I see VA providers fill out DBQs. Every once in a while, I'll see a good one that someone has, and they'll fill out great DBQs. But yeah, I don't know if there's some underlying message that VA sends out to their providers saying don't fill these out, or they just don't want to fill them out and they just use that as an excuse. I don't know, but I don't know a way to fix it because that's a separate entity that we don't really have any say in. Okay. Are you back?
Yes, I'm back. I'm relaxed. Isidoro Vasquez asked, evaluation of allergic rhinitis, which is currently 0% disabling, is increased to 10%. Assigned a 10% evaluation for allergic rhinitis based on rhinitis without polyps, but with complete obstruction of the left nasal passage. I have an appointment with an allergist this month. To receive a 30% rating, I need to have rhinitis with polyps. At my CMP exam, the ENT doctor didn't check for polyps. Should I tell the doctor I'm the allergist you're going to? What, Allison, did you have something?
Oh no, you froze. I was gonna step in, but you're
Okay.
good.
Oh, no. All right. Should I tell the doctor I need to get a check for polyps for my VA rating since I already have the symptoms of allergic rhinitis per the VA rating? Thank you. The allergist that you're going to, yeah, have them check. If you have polyps, then have the allergist make sure that that's on your report, and you could submit that medical record for a supplemental appeal for a higher rating. But yeah, if you have it and it's documented, you should be able to get that 30%.
Yeah, there's no alternative for 30% for rhinitis. It's you either have the polyps or you don't. So definitely get checked for it. A vet's life. How hard is it for women to get service connected for gynecological and FSAD, which is Rachel,
Female
female
sexual arousal disorder.
arousal disorder, especially with recurrent MC in
Miscarriage.
service? Oh, okay, you should read this one. Just kidding. Miscarriage in service as well as after and a blocked fallopian tube. Can I claim IBS and GERD together? Will they do 2 CMPs for each one? That's you, Rachel.
Okay. They would do 2 CMPs because GERD, they will do the esophageal, I'm not a doctor. They'll do that.
Esophageal.
Thank you. Allison is. They'll do an exam for, say it again?
Esophageal
Conditions
conditions.
for GERD. And then for IBS, they'll do gastrointestinal or like digestive disorders. So those would be 2 different ones. As far as getting service connected for the gynecological issues and FSAD, I definitely think if you had problems with reproductive system in service, that should absolutely be service connected. One thing I will say, which I came across the other day, if you're already service connected for any of those for a gynecological disorder, such as like a hysterectomy or fallopian tube or recurring problems, you may already be rated for SMCK, which is loss of use of a creative organ, such as any of those organs we just mentioned. If you already have that, you're not also going to get an additional SMCK rating for female sexual arousal disorder, because that in itself, like erectile dysfunction, the equivalent for men, is going to be rated 0%. You will get, if you get either of those conditions, you will get SMCK for loss of use. That's an extra $135 a month on top of whatever else you're rated for. But they're not going to give it to you twice. Actually, I think they do give it. They can give it to you twice, but they're not going to give it to you for if you already have SMCK for a gynecological disorder. They won't also give you female sexual arousal disorder. But the fact that you had all these issues in service, if you're not already service connected, definitely bring that up. Important to know if you are appealing that or in your initial claim, important to know, I'm going to take a wild guess that the problems you had in service have continued, like you mentioned, after service. So make sure that you know that these have been continuous, because a lot of times VA loves to look at service records and say, okay, yeah, well, you had these issues in service, but it was acute only. It was one time. It didn't really continue to the present day. So make sure that you describe the continuity of symptoms. That's always really important.
Also, what were your duties in service? Did you have any exposures? Toxic exposures can cause miscarriages. Where'd you serve? What was the base you served at? Is it a Superfund site now? Is it Fort McClellan? There are also things that you could have been exposed to in service that could have led to those gynecological issues. So that's also something to look into as well, and can give you additional evidence for service connection.
Alan says, what are the chances of winning sleep apnea on higher level review? Well, that is hard to answer without seeing what the evidence is. It depends. Higher level reviews have a higher chance of getting rated, a higher chance of getting granted than supplemental appeals. I don't really know the exact ratio on that. It really just depends on what you have. If you have a medical nexus on file, or you've shown, just like we talked about, if you snored during service and you have evidence showing that that's continued to be a problem since, then maybe the higher level reviewer is going to make a better decision than the initial rating board. But without knowing all what's at play, if it's secondary to anything, I can't say.
Agreed. Vols Duck. Go Gators. If I had a head injury while I was inpatient at the blind clinic in Augusta, and now I have signs of head injury problems, what type of claim could I claim it for? Well, I'm assuming that while you were inpatient at the blind clinic in Augusta, you were in service. Like Rachel was just discussing, continuity of care and showing that you've continuously have symptoms, that could be important. I mean, if you had a head injury 30 years ago and you're just now showing sign of head injuries now, that could be more difficult to prove. Also, what is the diagnosis that they're giving you? Head injury isn't a diagnosis. Is it some kind of cognitive disorder? Is it a TBI? That's the first step, is to figure out what the diagnosis is that they're giving you based on the head injury problems. Or is it that you're having migraines? That would be my first step. Rachel, what do you think?
Agreed. I would just claim, as far as like the simplest answer to that question, what type of claim you would claim it for, would be residuals of head injury. And residuals, just like Allison said, you need to identify what the symptoms are. Are you having headaches? Are you dizzy? Cognitive problems? Are you forgetting things? Getting kind of like lost in space? Are you having spasms? Any kinds of whatever you're having that you're noting these signs of head injury problems, make sure to specify what they are. That's going to help. And just like Allison said, you gotta like identify and have the actual diagnosis for whatever those residuals are before filing a claim. Or you can file it, but VA just won't grant it. Alan Elstad says, okay. Supplemental claim, Saipan Sailor. Supplemental claim after a few days is closed due to paperwork not sufficient. Now, what do? You lose claim. How does that work? Okay, so it depends why it was closed. So you know that it was closed. So they sent you a letter probably saying what you needed to do. They should have. They don't always. If you file a claim and they say like you didn't sign it or you didn't specify what the conditions were, VA is supposed to send you a letter and let you know so that you can correct that form. I was literally just today looking at the law, so I know specifically for supplemental claims, if you file something incorrectly, they send you the letter. Within 60 days of whatever that letter is from VA saying, hey, there's an error and you need to fix it. As long as within the next 60 days, you do whatever you needed to do to fix it and submit a completed claim, they are required to give you the same effective date as if your first claim was done perfectly and there were no issues. So just kind of depends on why they denied it. Take a look at that letter. If you don't have it, call the VA and ask for another copy. But whatever you do, find out why they denied it, why it was insufficient, and if you make that correction, you can keep your effective date.
Sometimes they'll close it out because they wanted it on a 526 new claim, and not a supplemental. Even though supplemental is the right form, I'll still file the 526, and then they'll come back and say the same thing. Sometimes it will be because there's no new and relevant evidence. Filing medical records, filing statements, anything to add to the record that can keep that claim open. Additionally, are some of the reasons why it could have been closed, or the paperwork wasn't signed or dated. If something's not dated or signed properly, they'll close it because of that. But like Rachel said, it should say on the notice that they send you. Okay, Darlene Stewart, 100% TDIU. There's another claim I could file. I was not going to, but with the possible changes to TDIU ending at full Social Security retirement age from the CBO, is it a good idea to file and rock the boat? Again, I do not like to rock the boat. I would say don't file it unless it's like a presumptive cancer or something that you would get 100% rating for, or could be eventually the cause of your death, unfortunately, and you're looking for getting your spouse benefits after you pass. That it really depends on what claim it is. If it's like tinnitus, no. If it's anything that's not going to add to your rating, no. If it's something that potentially could add to your rating where you have loss of use or something like that, a Parkinson's disease, things like that, then yeah, maybe. But it really depends on what the claim is. But anytime you go and you open new claims, they can go in your file. They can try to reduce things, proposal to reduce. Once you get 100% and there aren't conditions that can get you to special monthly compensation, I say leave it alone, unless it's like one of those claims that I just stated.
Yeah, that's really good advice. Don't risk something just like for a tinnitus or like a 10% ankle condition. But yeah, progressive disease or something like that, definitely. One thing I do want to say, you noted with the possible changes to IU, again, possible changes are not changes. Until those are made, don't make your decision based off of what could be changed in the future. So rocking the boat, that's true. Like you can rock the boat at any point, like Allison says. Rocking the boat is because they could potentially mess with your ratings and your current benefits. You don't worry about rocking the boat because of some potential changes down the line. That's not going to factor in. Okay, Chris A asks, part 4 question. All right. I have what I believe are 2 Qs, clear and unmistakable errors. The first, VA combined IU for migraines and anxiety. I lost my job due to migraines. I went to VA Voc Rehab and they said I couldn't work due to migraines. I developed anxiety at 70% because of losing my job. VA gave no rationale that migraines alone were considered preserving the right of SNCS. Okay. All right, let's answer this first one, and then we'll go to part 3 and 4. So I don't think it's a clear and unmistakable error that they didn't consider migraines alone, because remember, VA at the very most basic level, without looking at any of like the complications or exceptions, the person who's just going to look at your initial claim is going to see you don't have one condition rated at least 60%, or that they're just going to look at the combined rating. They're not going to consider migraines on their own, even if you're rated at 50%, which is the maximum rating. They don't go higher, even though, just like Chris, they can impact so much of your life, including your inability to work. So while it might not be a clear and unmistakable error, what I would do, you're still entitled to have your migraines considered under one of those exceptions that whoever made this initial decision just didn't look at or wasn't aware of. There is a rule where even if you don't have the minimum rating to have individual unemployability, which is 70% combined rating or a single condition rated at 60%, in your case, you have migraines rated at 50%, you can specifically ask VA and use these words: extra scheduler rating. Extra scheduler, outside the schedule, meaning you're seeking compensation above and beyond what the schedule provides for. So IU only due to migraines, that's above and beyond 50%. But that doesn't mean that it won't be granted, because there's exceptions for a reason. And that migraines is a really big one that I have seen VA grant under this purposes. Now, it's not going to be like a quick decision, because when you ask for extra scheduler consideration, such as IU due to migraines alone, VA has to send it to a special department, to the Director of Compensation Services. And that department just looks at claims like that. Okay, let's look at Chris's claim and let's look at the evidence in here. He got fired for migraines. He didn't get he didn't finish voc rehab because of migraines. They should look at all the evidence, and they'll get a memo, and then you'll eventually get a decision. It won't be quick. I don't think it's a queue, but you're absolutely right that if they do grant migraines, IU for migraines alone, if you've got an additional condition that's rated at least 60%, it sounds like your anxiety is 70, you should have SMCS. So I wouldn't take it laying down. I would ask for extra scheduler consideration.
I agree.
Anything to add on that, Allison?
No, I agree. Q is really, really difficult to prove. It has to be such a blatantly obvious error that anyone looking at it would see that it's an error and it needs to be rectified. I don't think it's Q. I think it's just a way to get SMCS that wasn't considered, and you have to bring that up to get them to consider it. And so, yeah, I agree with Rachel. Just ask for them to consider it extra schedularly.
Mm-hmm. And then he had a part, yeah. You want to take this one?
I have pes planus connected at 0%. The rationale stated, I have swelling of the feet and much pain. Since my symptoms are not relieved by orthotics, I'm rated at 0%.
If your symptoms are relieved by orthotics, you should be 0%. But if they're not, you should have a higher rate.
Correct. Yeah. If you have orthotics and your symptoms aren't relieved and you're still having pain, then you should get the 10% rating. But if they are relieved, then they aren't. So if you're saying that they aren't relieved, then you should have it. And you're having pain with the feet. The hardest part of that is having documentation for it. I would make sure that in your medical records that it states that you have pain and constant swelling and such. But oh no, it's just that's all. I think.
Oh, okay.
I think that's it.
Gotcha. Yeah, I agree. It is really hard to get that documentation.
Yeah, it's difficult. People aren't really documenting for the feet. But if you get documentation stating that you don't get relief from the orthotics, then I would appeal that.
Okay. Alec Y, 60 years old, received 90% in TDIU, permanent and total, but was denied IBS, GERD, and hemorrhoids. I had submitted POS, IMOs, independent medical opinions for all, but the CMP opinion was not service connected. Should I just not pursue those denied conditions? Well, I think if you've seen the last 48 minutes, you know what me and Allison are going to say. Although I think I might be more inclined to lean with Allison on this one. I would leave those unless they really, really impact like your everyday life.
No, because it's not going to give it unless it can get you up to schedule 100% rating and you are trying to go back to work. But you could be at 90% and you could be at 91 and still need 50, 60% more. IBS max you're going to get is 30%. GERD, you're most likely going to get 0, maybe 10. Hemorrhoids, you're going to get 0. And those aren't conditioned. I mean, the IBS potentially could lead to special monthly compensation, but without more details, I would leave it alone. Jacob C., can you talk more on independent living through the voc rehab for payment? I don't know.
Can't. Actually, I'm not informed on voc rehab.
Yeah, I don't know anything about that. Wayne K., I know this is a lengthy subject, but can you talk about SMC? Okay, so basically what SMC, it's special monthly compensation. So it's Compensation separate and above the 100% rating that you can get. There are many different levels of special monthly compensation. Like we said earlier, you can have special SMCK, which is like loss of use, whether it be loss of use of a hand or loss of use of a creative organ. That would be SMCK, where you just get a separate, I think, like $100 addition, 135 to your compensation. So you can get SMCK regardless of if you have a 0% rating or 100% rating. Once you get to 100%, or even without 100%, let's go back. There's SMCL, which includes aid and attendance. Now, if your service-connected conditions affect your ability to do your activities of daily living, you need assistance with bathing, you need assistance with walking, you need assistance with feeding, dressing, things like that, brushing your teeth, then you can file a VA 2680 form asking for aid and attendance, which would be SMCL. You don't necessarily need 100% rating for that, but they probably
the regional office thinks you do.
Yeah, the regional office thinks you do. And you would have to appeal that. Then from there, once you get, there's also
let's do SMCS. Let's do SMCS, which is probably
so then SMCS is, you'll see it, and I had one vet very upset about this. It's called, it'll go on your rating decision stating that it's housebound, but that's just one way to get it. Just because it says housebound doesn't mean that's why you're getting it. So one way to get SMCS is if your conditions make you housebound and it's difficult for you to leave your home. Another way would be, another way would be if you have 100% rating for one condition, and let's say you have 100% rating for prostate cancer, even though you're getting treatment and it could go away, it doesn't matter. You have 100% rating. Then you have 50% for migraines, 10% for tinnitus, and 10% for bilateral ankles. Once you get an additional 60%, you automatically qualify for SMCS. So they should automatically give you that. Another way to get that would be if you get individual unemployability based on one condition. So you have a 70% rating for PTSD, you get individual unemployability solely based on the PTSD. You have a back condition, you have radiculopathy, you have other conditions that lead up to additional 60%, then you can get SMCS. With that, though, you have to have only one condition for the individual unemployability. And so when you get granted individual unemployability, it'll tell you what conditions it was service connected for. If it's PTSD and tinnitus, you're not going to qualify for it.
That's what Chris was asking just earlier with the migraines. That's because the conditions were considered together, he couldn't get SMCS.
And then from there, you can start to get into
a whole nother video.
Yeah. From there, you get into loss of use of your extremities. If you have loss of use of the feet, you can get SMC. Oh gosh, is it N or M? One of them is feet, one of them is hands. And then as you add those conditions up, you can go up higher. Then you can get to a point where you have, you can qualify for SMC R1 and R2, which is you need, how do I describe what that is? SMC R1 is when you need a higher level of assistance with your activities of daily living, whether it be a medical professional, like having your wife or your spouse changing your catheter, emptying your catheter, giving you insulin shots, things like that. Those are higher levels.
That's R2.
No, R2 is if you're a medical professional, like you need
required training.
Or required training, yes.
With changing a catheter, if somebody is doing that, that's R2. But no.
Oh, I was gonna say they're not gonna be changing the catheter; they'll just be emptying it. And then so go ahead. R. You have anything else for R?
There's R1 and R2, and R1 is if you have certain combination of disabilities and you need aid and attendance. That does not require the higher level of care that we're talking about. it obviously requires great care, but it's something that you don't have to be medically trained or get instructions from a medically trained provider to do it. And that's stuff that you need aid and attendance for, helping get in and out of the shower, helping get dressed, needing someone to prepare meals, manage
But to get
medication.
to R1, R2, you have to have like that loss of use of the lower
Yes.
extremities, or loss of use of the upper extremities. You can't just get there and say like, oh, I need a higher level of aid and attendance. And so what happened was people with TBI weren't having loss of use of their extremities, but they had these severe conditions where they needed a higher level of care. So Congress carved out a separate special monthly compensation for them, which is SMCT, which basically you don't qualify for R1 or 2 because you don't have the loss of use and such, but you have such residuals of TBI that, but for whomever is caring for you, you would need to be put in a nursing home or an institution or something like that. And those are all the special monthly compensations, and they're very complicated. We have videos on them to get more thorough information on all of them, but that's just a general rundown of them. And with that, we will do one more question.
All right, Grace Smith. X number of years, mental health, CMP denied, no, 20 years, maybe, denied no service treatment records, and CMP denied, anxiety not specified. I'm seeking treatment. Can I file? And what do I file? Supplemental. Okay, so the CMP, okay, let's start with diagnosis. Anxiety
Yeah,
not specified. That's a fine
doesn't
condition
matter.
to have service connected. It doesn't matter. You don't have to have a specific diagnosis. They do that a lot, or they'll say unspecified stressor disorder. They have funky names, but it doesn't matter as long as there's a diagnosis that fits the diagnosis part. You're seeking treatment, and the CMP is denied, and there's no service treatment. Okay, so what you would do to file a supplemental appeal, you need new and relevant evidence. So
Well, first, why was it denied? Was it denied because there was no diagnosis? And they're saying that that isn't enough. Well, then you would want medical records for that. Or was it denied because you were asking for PTSD and they said you had no diagnosis of PTSD, but then failed to even consider the anxiety? Then from there, was there no stressor in service if it's PTSD, or was there no incident in service if it was another mental health condition? And then from there, if you have both of those, is it because just the CMP was negative? And if you have the condition and you have the incident in service, then all you'll need is a nexus opinion from there. But you have to look at your rating decision. Was it because of the diagnosis? If it was because they looked at PTSD and they didn't look at the anxiety, I would file a higher level review and say, I have a diagnosis of anxiety. You need to consider this as well. And I have an incident in service. Or was it because you didn't have an incident in service? Then you're going to have to look for records for that. Or do you have a current condition where the anxiety could be secondary to it, like back condition, orthopedic conditions cause a lot of pain, migraines, any of those? That would be something else. Sorry, Rachel, go ahead.
no, that was a very good rundown. Yeah, I would still say get your treatment records from your current treatment. Submit those as well if you end up with a supplemental appeal. If there's not an incident in service, or rather, there's not a documented incident in service, you'll want to do statements. You want to do a statement of yourself, what happened when the symptoms started. You get statements of family members, friends, to be able to talk about the changes before and after service. Even if it's not PTSD and it's a different diagnosis, you can still be service connected. All right.
Well, that was a lot of talking today. Hope we answered your questions. And if we didn't, come back next week and put them in there. Get in early in the chat. And we usually do them in order. So try to get in early and put your questions in. But we appreciate your time. Please look at our other videos for more in-depth analysis of any of the topics we discussed. And thank you for your service, and have a wonderful rest of your Wednesday.